Namaskar. Continuing with our video series on the refresher training manual for ministerial staff from the state of Punjab, Haryana and UT Chandigarh. Today we shall look into chapter 10, which deals with record room, destruction of judicial records and duties of record keeper. Now, record room constitutes very important part of judicial courts. It is a place where all decided files are consigned. Record keeper is in charge of record room since the space in record room is limited, but at the same time the record is valuable, therefore proper procedure is prescribed for weeding out the records. Duties of the record keeper are given under volume 4, chapter 16A. Under part A 2, rule 5B, file of every decided case should be consigned to the record room within the period of 15 days from the date of the final orders. Volume 4, chapter 16A, rule 5B says that if there is default, explanation of the helmet for the delay duly signed by the presiding officer should accompany the record. Volume 2, chapter 8D, section 6 says, consigning record, the reader of the court shall attach to it a certificate that undisbursed deposits of diet money payable to witnesses and newspaper payments for publication have in all cases where necessary been refunded to the depositors. The record keeper should not receive the record unless this certificate is attached to it. Volume 4.1, chapter 10D says that record keepers should not receive into their record rooms any record in which property appears to have been made over to the civil nazir, unless the acknowledgement of the civil nazir, the number given to the deposit in his register, have been duly entered in the record. On the second day of the first month of each quarter, the register of files taken out of the record room should be checked by the record keeper, and a list of the files not returned to the record room should be prepared and forwarded to each court for verification. Volume 4, chapter 16A, rule 6 speaks that on receipt of the case in the record room, the record keeper will examine the index and check the entries in column 1, 2 and 6 with the papers and stamps in the record and sign a certificate on the foot of index that record is complete. Volume 4, chapter 16A, rule 6 says that he shall enter the case in its appropriate register. Volume 4, chapter 16A, rule 6 says that if any papers or court fee stamps are missing, he will at once bring the deficiency to notice. The keeper should ensure that every civil and criminal file should be properly indexed in the prescribed form. Record keeper to see that before consignment, civil records are arranged in 3 parts: A small 1 and B as stated in volume 4, chapter 16, rule 3. Rule 5 speaks that all civil records and criminal records shall be arranged in 2 parts, A and B, that we have already dealt in chapter 5. Inspection of decided files are given under volume 4, chapter 16 of High Court Rules and Orders. Rule 1 says the records of decided cases shall be open to the inspection of the public, subject to general control of the head of the office. Rule 3 says that the inspection of records of decided cases shall be made at such time in such place and in the presence of such official as the head of the office may order. Rule 4 says that application for inspection of records shall be made in writing. It shall specify the record to be inspected. If inspection of civil case, 1 rupee court fee stamp, and if inspection is required of the records of a decided case other than a civil case, 2 rupees court fee stamp shall be charged as search fee. Rule 4A says that no fresh application is required if the applicant wants to continue inspection from day to day consecutively. This will not affect the fees payable under Rule 5. Rule 5 says that the inspection fee for each day or part of the day shall be ₹2 for ordinary and ₹3 for urgent inspections, that is, on the date of hearing. Urgent fee is, however, not to be recovered when inspection is carried out after the hearing is over, even though it be done on the date of hearing. Inspection of challan cases should, however, be allowed at ordinary fees even before the case is heard on the date of hearing. The fee provided above shall entitle the applicant to inspect the record on one day only. If inspection of the record is desired on another day, a fresh application is required and a fresh fee paid. C says that a separate application shall be made and a separate fee paid for each record unless the records can be regarded as one. Rule 7 says that no mark shall be made on any record or paper inspected, and no servant of any member of the bar shall be allowed on any account to take notes for his master except in the presence and under the supervision of his master. The copying of any document or portion of the record in pen and ink is strictly prohibited, but pencil copies of a document or portion of the record may be made by counsel or under his supervision and his presence by his clerk or servant. Any person violating the rule shall be denied the right to inspect records for such period as the head of the office may think fit. The destruction of the records includes destruction of waste paper as given under Volume 4, Chapter 16F of High Court Rules and Orders. The destruction of records and registers shall be carried out under the supervision of the record keeper. He shall effect it by tearing. He should take care that all court fee stamps have been duly cancelled. The paper shall then be sent to the nearest paper-making jail after ascertaining from the jail concerned whether it does require the waste paper. The paper should be sold in the open market. If the reply of the jail is in the negative, the sale proceeds shall be credited to the head 21 Administration of Justice, miscellaneous fees and fines, judicial record room receipts. The following are the paper-making jails: Ambala District Jail, Hisar District Jail and Gurdaspur District Jail. Rule 7 speaks with regard to the following records which shall be preserved in perpetuity. Part A of all suits and appeals involving title to immovable property. Part A of all suits and appeals relating to the succession to an office or to establishment or set aside an adoption or determine the status of an individual, and of all suits and appeals relating to trust or religious endowments. Records of attachment, sale and delivery of immovable property and execution of decrees. Part A of proceedings under the Indian Succession Act of 1925. Part A of the proceedings under the Indian Divorce Act 1869. Records relating to the disposal of immovable property forfeited to government under Section 62 of the Indian Penal Code. Insolvency proceedings under the Provincial Insolvency Act 1920, where the court has decided a question of title to immovable property under Section 4 of the Act. Correspondence with other officers on matters connected with the administration of justice, including annual reports and the statements appended thereto, provided that heads of offices may, with the previous sanction of the district judge, order the destruction after 3 years if any correspondence of a merely formal or ephemeral character, after personally satisfying themselves with regard to each paper ordered to be destroyed, that its retention is no longer necessary. Also, annual confidential reports on the work of magistrates and subordinate judges, stipendiary and honorary, may be destroyed 5 years after the end of the year to which they relate. Part A of proceedings under the Indian Union Act. Part A proceedings under the Companies Act or under the Banking Companies Act. A list of all papers proposed to be destroyed must be prepared and, in the case of subordinate office, be submitted to the district court for sanction. This list will be preserved in perpetuity. Records to be preserved for 60 years is given under Rule 8. Part A of proceedings under Section 1 and 8 of Regulation 17 of 1806, Bengal Land Redemption and Foreclosure Regulations 1806. 9 speaks with regard to the records to be preserved for 50 years. Part A of proceedings under the Guardians and Wards Act 1890, records of insolvency proceedings under all acts. Part A of the cases relating to any of the offences specified in Section 44 of the Code of Criminal Procedure as offences of which all persons are bound to give information, in which any of the suspected persons have escaped apprehension. Whenever it is known that the offenders or offenders on whose account such records are kept are dead, the records may be destroyed. Part A of the criminal cases in which the offence is punishable with death and it is not known that who the offender is. Part A of the criminal cases in which a lunatic is concerned unless the lunatic shall have been subsequently tried or have died. It speaks with regard to the records to be preserved for 20 years. Part A, small I, the civil records specified in Rule 3 above, the charge, finding and sentence in cases in which conviction has been had of an offence for which enhanced punishment is provided on a second or subsequent conviction. Part A of cases in which any public servant has been tried, whatever may have been the result of the case. Part A of all civil suits and appeals other than suits and appeals falling under Rule 7, where one of the parties is a minor suing or sued through a guardian under Order 32 of the Code of Civil Procedure. Part A of criminal cases relating to any offences other than those specified in Section 44 of Code of Criminal Procedure, in which any suspected persons have escaped apprehension, provided that whenever it is known that the suspected offender or offenders on whose account such records are kept are dead, the records may be destroyed. Rule 11 speaks with regard to the records to be preserved for 12 years. Part A of sessions cases provided that if the sentence has not been fully executed, the record shall be preserved until the return of the warrants and then destroyed. Part A of cases under Chapter 36 CRPC in which maintenance is awarded. Insolvency proceedings under the Provincial Insolvency Act where immovable property is involved. Part A of proceedings under the Guardians and Wards Act 1890. Rule 12 speaks with regard to the records to be preserved for 6 years. Part A of all civil suits and appeals other than suits and appeals falling under Rule 7, provided that if the decree has not been fully executed or become incapable of further execution, Part A must be preserved until such time as the decree has been fully executed or become incapable of further execution. Part A of cases tried by the magistrate of the district under Section 30 of the CRPC in which he has inflicted a heavier punishment than might have been inflicted by a magistrate of the first class, provided that if the sentence has not been fully executed, the record shall be preserved until the return of the warrant and then destroyed. Records relating to the realization of fines of criminal courts. In January, April, July and October, record keeper will receive from civil courts list of execution cases in respect of records which are 6 years old or about to become 6 years old in which decrees have been fully executed or have become incapable of further execution. On the receipt of these lists, the record keeper should make a note to this effect that on each file, and he should not destroy any file unless it contains this note without ascertaining whether the decree has been fully executed or has become incapable of further execution. Only such portion of the record, if any, as relates to the attachment, sale and delivery of immovable property in execution of decrees, including all objections, proceedings and orders thereon, should be taken out and preserved permanently as required by Rule 7 when the record is destroyed under Rule 12. Rule 13 speaks with regard to the records to be preserved for 3 years. The following records shall be preserved for 3 years and shall then be destroyed. Insolvency proceedings under the Provincial Insolvency Act where no immovable property is involved. Records of criminal cases inquired into or tried by the magistrates and not otherwise provided for in these rules. Part A of appeals from orders passed by the magistrates. All correspondence between the district magistrate, district judge and subordinate courts and other records, periodical statements, reports, proceedings, applications, etc. provided that in respect of records falling under this clause, heads of offices must exercise their discretion in preserving reports, returns, and proceedings likely to be useful in the future as containing the result of inquiries or other information or the opinion of the experienced officers on matters connected with the general administration of justice. Rule 14 speaks with regard to the records to be preserved for 1 year. Part B of all civil and criminal cases and appeals provided that papers relating to deposits and payments thereof shall be separated and preserved until such time as the accounts of the deposits and repayments concerned have been audited and any objections raised in connection therewith have been finally settled. That Part B of civil cases and civil appeals in which a first or a second appeal lies to the High Court shall not be destroyed until the period of limitation for instituting such an appeal has expired or until the appeal, if instituted, is decided by the High Court. Proceeding of other cases, other courts and officers forwarding notices, proclamation, calling for record, etc. Rule 14A speaks that records to be preserved in digital form, that the original record in physical form should also be preserved in digital form. Mode of reckoning period. Rule 15 speaks that the period for destruction of record shall be taken to run from the date of the final order of the court of first instance or in the event of an appeal from that of decision of the appeal. Rule 15 also says that in cases under Chapter 36 of CRPC in which maintenance is awarded, the period shall be taken to run from the date of the last order passed for the enforcement of the award. Rule 17 speaks with regard to the record keeper to preserve government papers and papers of private persons. Before destroying Part A of any judicial proceedings, care must be taken to separate and remove from the record all documents belonging to private persons or to government as a party to the proceedings which have not been superseded by the decree or impounded in the case in which they were produced. These documents shall be preserved and tied up in a separate parcel. And notice shall, whenever practicable, be given to the persons who produce them in court, requiring them to take them back within 6 months from the date of the notice and warning them that they will be kept at their risk and that the court decline all responsibility for them. Copies of this notice should also be put up in conspicuous place of the courthouse of the Deputy Commissioner of the district and of the court in which the suit was tried. Heads of offices must make the best arrangement for the custody of these documents. Rule 16 speaks with regard to the attestation of record keeper on notes of destruction. When under above the rules, the whole of the papers of Part A of record are destroyed, a note to the effect shall be made at the time of destruction against the entry of the case in the Goshwara. In the case of the record of offices of district and sessions court where no Goshwaras are kept, the note shall be made against the entry of those cases in the general register. When some of the papers of Part A of the record are destroyed and some are retained, a note of the papers destroyed shall be made at the time of destruction on the fly index of the case. All notes made under the above instruction 1 and 2 shall be attested by the record keeper. No note need be made of the destruction of Part B of a record. Such destruction will be presumed to have been effected in accordance with Rule 14. 6 speaks with regard to the personal file of officers and ministerial and menial servants of government who die while in service shall be preserved for 3 years after their death and then destroyed, provided that there are no outstanding claims on the part of their heirs. Who have retired shall be preserved until their death and then destroyed, provided that no file shall be destroyed before 3 years from date of retirement when death occurs within 3 years of retirement. Rule 27 says that vouchers relating to contingencies should be preserved for 3 years and then destroyed, and this period being reckoned from 1st January following the date of payment. Rule 28 says that the records relating to sheriff's, petty and civil court deposit accounts shall be preserved for the period noted against each in the subjoined statements. Preservation of registers is given under Volume 4, Chapter 16F. See that for civil registers, it includes register of civil suits, register of miscellaneous suits with a cognizable only by the principal court of original jurisdiction, register of divorce and matrimonial cases, register of cases under the Land Acquisition Act, register of probates, letters of administration and succession, certificates granted, record keepers general register of suits and appeals disposed of, register of documents returned. And so far criminal registers are concerned, register number 7, register of succession trial and of references made to the Court of Sessions under section 123 Criminal Procedure Code, register number 8, register of trials of European, British subjects, and register number 16, record keepers general register of decided cases, are to be preserved till perpetuity as per Rule 18. Now, the following registers shall be preserved for 50 years from the date of the last entry and then shall be destroyed as per Rule 19. That civil register includes register number 26 relating to the property of minor and in an annual account of their estates. Register number 27, register of persons adjudicated insolvents and administration of their estates. Criminal register includes register number 9, that is registers of complaints against or inquiries into conduct of the servants of the government. Miscellaneous register number G, that is register of ministerial officers, and register number I, that is register of affidavits. The registers to be preserved for 20 years as per Rule 20 include the civil register number 10 of execution of decree, register number 11 of miscellaneous petitions and execution proceedings, register number 13 of appeals from decrees. So far criminal registers are concerned, register number 2, register of cases under the Indian Penal Code, register number 10 of appeal and revisions in criminal cases, miscellaneous register number A, register of contingent expenditure, and register number H of petition writers. The registers to be preserved for 12 years as per Rule 21 includes the civil register number 6, that is register of miscellaneous petition and application, register number 14, that is register of miscellaneous appeals. Criminal registers include register number 1 of cognizable and non-cognizable offences instituted on complaint or on magistrate's own motion or reported by the police under section 157 and 173 Criminal Procedure Code, register number 3 of cases under special and local laws and under the Code of Criminal Procedure, register number 4 of miscellaneous criminal cases, register number 14 of judicial fines. Civil registers and criminal registers to be preserved for 6 years as per Rule 20 are register number 16 of judgment debtors imprisoned in execution of decrees, register number 18, register of stamp deficiencies to be maintained by courts and officers, register number 21A for special Kanun Go, register number 21B of commissions which is used to the special Kanun Go, register number 25 of deposits and refunds of commission on sale proceedings and execution proceedings, register number 25 of judicial fine and realization, miscellaneous register number B of files taken from the record room for reference, provided the register number 2018 and other registers mentioned in this rule shall be preserved for a longer period if necessary. Such registers shall be preserved for a period of at least 3 years after the date on which all dues in respect of the deficiencies in stamp duty and court fees pointed out by the stamp auditors are recovered or written off. The following judicial registers shall be preserved for 3 years from the date of the last entry and shall then be destroyed, including civil register number 7 of application to sue appeal as pauper, register number 8 of rejected and returned plaints and memoranda of appeal, register number 9 of dates fixed for trial of original suits, appeals and execution of decrees, register number 12 of application for review in suits and appeals and for amendment of decrees, register number 17 of persons punished for contempt of courts, register number 21C of inspection notes, register number 22 of warrants executed by bailiffs, register number 23 of processes served by the process server. Criminal register number 5 of cases decided in each court. Number 6, register showing the number of offences reported and brought to trial and of persons discharged, acquitted or convicted. Number 11 of dates fixed for trial of criminal cases, including dates of receipt of cases sent up for trial by the police. Register number 12 of prisoners under trial. Register number 13 of persons admitted to and removed from the lockup in the district. Miscellaneous register number C of miscellaneous proceedings received from other districts or courts, register number D, of dispatch of packets or letters, register number E, of general orders issued in the Judicial Department, register number F, of property received into the Nazir storeroom. Other duties to be performed by record keeper include record keeper to obtain list of cases disposed of during the month by reader. It is a duty of the reader to submit list to the record keeper every month. Record keeper to check the files as per index, entering the decided files in the registers and giving Goshwara Diwani or Goshwara Faujdari number to each file, providing Goshwara numbers, Diwani numbers to the concerned readers, sending photocopy of requisition record to Honorable High Court or other quarters, sending original files to record to courts on receipt of dockets, providing files to copyists of record room for preparing certified copy and ensuring return of files complete in all respects after preparation, appearing in courts, along with judicial file on receipt of dockets, reporting by the record keeper on applications filed for return of documents of decided cases. Rule 5A speaks copies of challans retained by the record room staff will be kept for 3 years and destroyed thereafter. If the High Court demands a case file, it is the duty of the record keeper to send the photocopy of the demanded file duly attested to the High Court. The record keeper with his helping staff arranges the files according to date of decision or officer or area as per practice of a particular sessions division. The files are tied in bundles and are kept in properly date-wise in the record room so that they may be traced immediately when demanded. When the file is sent to the court on receiving the docket, the same docket is kept in place of file, and after receiving the file back, the docket is removed and file is kept on its original place. The traffic challan, which accumulate in great numbers, are to be treated with traffic number, TRF number. Spraying of pesticides is done every 6 months so that the file may be saved from termite or any other insect. Important registers of record keeper as per volume 4, chapter 24. Record keeper is to maintain criminal register 17, that is record keeper's general register of decided cases, civil register 15, that is record keeper's general register of suit and appeals disposed of, miscellaneous register number B, that is register of files taken from the record room for reference, register number 24, register of documents returned. The record keeper will maintain this register for return of documents in cases which have been consigned to the record room. This is all about the record room and the duty of the record keeper. Now, in our next video, we shall be dealing with chapter 11, that is Sheriff's Petty Accounts, Civil Court Deposit Accounts, and Duties of Civil Nazir. Till then, Namaskar.